I was watching this YouTube stream from Bunny Boots Inc. and it was Mikey Bluehair was interviewing Ida Foxy Queen, and they got into their little anarchy discussion, which I find hilarious because anarchy is ridiculous. But I did notice that Ida made this comment.
Services that you're providing me with by your stolen freaking funds. You don't have any duty to protect me. What are you doing? What is
She went on to go and say that every Supreme Court case has essentially ruled that there is no duty to protect. And I noted in the comments while I was messing with the less thoughtful supporters of Ida that she was misunderstanding and misconstruing what the court was saying. And I was asked to prove it in the comments. And so I shall, or at least I'll attempt to prove it. So, generally speaking, in torts, if you're going to go for some sort of negligence claim, you have to prove that a duty exists between the plaintiff and the defendant. A duty generally is an obligation that requires the defendant to conform to a certain standard of conduct for the protection of the plaintiff against unreasonable risk that not doing would allow, breaching that duty would allow the plaintiff to sue over. And that's important. So, for example, a waitress has a duty to serve clients, patrons, customers, what have you, but the patrons can't sue her for not serving them. Generally speaking, obviously, if she's not serving them because of race or some other protected class, then perhaps something else will provide a means of suit. But generally speaking, just average waitress, average customer is unhappy with the time it takes for that waitress to provide service, they can't sue. So that is important that the plaintiff has to be able to sue over the breach of duty. So generally there's no affirmative duty to aid or protect a plaintiff unless the defendant's actions put the plaintiff in the position where they need the aid or protection. Like if I bumped into you and knocked you off a bridge into a river and you were going to drown, where normally I would not have a duty to jump in and save you, now that I have placed you in that position, I now have a duty to rescue you. And you would be able to sue me if I didn't. If, however, I was walking along the street and I see you fall in, I have no duty to protect you, even if I'm a world-class sprinter and a licensed swimming, instructor, and I'm a lifeguard and all these other things. If I don't save you, there's still no duty on me to do it if it's not my job, if nothing else puts me in that position, if you haven't paid me to protect you, etc. I'm a random guy walking down the street. I see you randomly fall into a river through no fault of mine. I have no duty to save you. There's a couple other positions where that duty may arise. Like if I see you fall into the river and I shout at the crowd who sees you fall into the river, I'll save her. Everybody else stay here where it's safe. At that point, I'm creating a duty because I've stopped other rescuers from going in after you. Now I may be liable to you if I jump in and attempt to start saving you. Depends on the state It may, generally speaking, that would probably cause a duty to arise between us. And the only other time is when there's a special relationship between the plaintiff and the defendant. So if, like, a parent would have a duty to protect the child. If my child falls into the river, I have a duty as a parent to go in and rescue it. If a warden and a prisoner, if the prisoner needs medical attention, the warden has a duty to get that prisoner medical attention. So you can create a special relationship. Some big cases that the Supreme Court has dealt with on that have been the duty of the warden to provide health care for prisoners, the duty of the doctors and nurses at state-run hospitals to investigate harm that's been done to inmates. So you can create a special relationship. There's a slightly different form where that special relationship can come into play, where there's a duty to protect third parties, which would be if, like, a master-servant relationship, an employer has a duty to protect customers from their employees. A warden has the duty to protect the citizens from escapees, etc. There's a duty to warn, a duty to protect, things like that will kick in. So generally it comes down to if you have a special relationship with the plaintiff, or if you have a special relationship with somebody else that would cause you to have control over them, or that where you should have control over them, then that could expose the defendant to liability. Now, in general, the government is excused. They generally find that there is no duty if the government has discretion. So if there's a fire and your house burns down and the city takes too long to respond because they only have one fire engine because they have used their resources on other things, you can't sue them for not having enough fire engines. If they have enough fire engines, but maybe there's two fires, and the city decides to send their fire engines to the first fire, causing them to arrive at the second fire too late, you can't sue them because they have complete discretion over that. It would place the city or the state in a ridiculous position if they were responsible for every building that burned down. And then there's also ministerial functions. So it's called the public duty doctrine, and I learned it as duty to all, duty to none. And that came from this case. This is a U.S. Supreme Court case from 1855. It's really old, but you'll see it echoed through more recent cases. And what happened in this case is there was a breach of the peace, and I believe the sheriff saw it. It's written in 1855 legalese. It's not fun to read, but the gist of it is that there was a breach of the peace. The plaintiff, I believe, was kidnapped and held for 4 days for ransom, and the sheriff didn't act on it. And what this court ended up holding was that it's an undisputed principle of the common law that for a breach of public duty, an officer is punishable by indictment. So if it's a breach of public duty, an officer is punishable by indictment. It's not saying there is no public duty. It's saying if there's a breach of public duty, the officer is punishable by indictment. That's not by being sued, that's by actual criminal charges. But where he acts ministerially and is bound to render certain services to individuals for a compensation in fees or salary, he is liable for acts of misfeasance or nonfeasance to the party who's injured by them. The powers and duties of conservator of the peace exercised by the sheriff are not strictly judicial, but he may be said to act as the chief magistrate of his county, wielding the executive power for the preservation of public peace. It is a public duty, for neglect of which he is amenable to the public and punishable by indictment only. Breach of the peace is to the public. So if there's a special relationship between the police and the person who's harmed, then a suit is possible. So, for example, if the police have placed the plaintiff under arrest, placed the plaintiff in the back of the police car, and then proceed to drive negligently, get in an accident, and cause harm to the plaintiff, where he was in the position he was in, and everything is the cause of that police officer, then because of that, he was placed in there by the police and there is that special relationship now, then the police can be held liable for monetary damages. And that goes back to the special relationship that we were talking about earlier between, for example, a master and servant, or a custodian and a prisoner. So that's where that comes from. Now, what I want to point out is there is a duty to the public in this, and that's where that other term for this comes from: the duty to all, duty to none. The public at large is who the sheriff owes a duty to, or the police in this case would owe a duty to. So we go to the more recent cases. I'm going to start with DeShaney versus Winnebago City. In this case, a child was left with his father, who abused him to the point where the child suffered permanent brain damage. The city, I believe it was the city. Yeah, it was the city. It was their Department of Social Services. They had cause to believe that the child was being abused, and they had taken steps to try to effect change. They had talked to the father. They had set up steps the father needed to go through, but they hadn't pulled the child. They had left the child in the father's care. And what the court held was that nothing in the language of the due process. So what the plaintiff ended up doing is they ended up suing under the due process clause of the 14th Amendment. And the due process clause of the 14th Amendment says that you won't be deprived of your life or liberty or property without due process of law. And in this case, he was deprived from his health. But it says nothing in the language of the due process clause itself requires the state to protect the life, liberty, and property of its citizens against invasion by private actors. The clause is phrased as a limitation on the state's power to act, not as a guarantee of certain minimal levels of safety and security. It forbids the state itself to deprive individuals of life, liberty, or property without due process of law, but its language cannot fairly be extended to impose an affirmative obligation on the state to ensure those interests do not come to harm through other means, nor does history support an expansive reading of this constitutional text. So the court here is saying that because in this case, there was no special relationship between the plaintiff, the child, and the state, which would be the city, that the 14th Amendment due process clause doesn't kick in. Therefore, the 1983 lawsuit doesn't work. You have to establish that special relationship. Had the state taken the child into their custody, had they removed the child from the father, and then through the negligence or malfeasance of the state, they caused the child to become brain damaged, then absolutely there would be that special relationship. But the father wasn't a state actor, and the state hadn't created that special interest, that special relationship with the child by taking guardianship of the child. And it goes back to the ministerial functions: duty to all, duty to none. The state had a duty to the public. They were exercising their discretion by not taking the child away from the father. And if they made a mistake, that sucks. But that doesn't mean the child can sue over it. The child can still sue the father, obviously. But in this instance, the father doesn't have any money. So they're looking for an alternative revenue source for the child. Now, the child is going to be put up at state expense, which means obviously your and my expense, for the rest of his life because he's brain damaged. But he can't recover additional monies. So finally, we get to Castle Rock v. Gonzalez. In this case, they try again. They do a 1983 lawsuit. In this case, the mother had the child. She had a restraining order against the father. The father violated that restraining order and took the child and proceeded to kill the child. And that's terrible. And the argument in this is that because the state had given them a restraining order, that the state had created that special relationship. And what the court held in this instance is that it did not. We conclude, therefore, that respondent did not, for the purpose of the due process clause, and again, this is for the due process clause that they're making this analysis. So they did not, for the purpose of the due process clause, have a property interest in public enforcement of the restraining order against her husband. It is accordingly unnecessary to address the Court of Appeal's determination that the town's custody or policy prevented the police from giving her due process when they deprived her of that alleged interest. In light of today's decision, and that in Descheny, which was the Descheny v. Winnebago that I referenced earlier, that benefit that a third party may request or may receive from having someone else arrested for a crime generally does not trigger the protections under the due process clause, neither in its procedural nor in its substantive manifestations. This result reflects our continuing reluctance to treat the 14th Amendment as a font of tort law. But it does not mean states are powerless to provide victims with personally enforceable remedies. Although the framers of the 14th Amendment and the Civil Rights Act of 1971, the original source of the 1983 statute, did not create a system by which police departments are generally held financially accountable for crimes that better policing may have prevented, the people of Colorado are free to craft such a system under state law. So to wrap this back to what Ida said, there is no specific duty that is recognizable at law for the police to protect you. There is a duty for the police to protect the public. That's been stated several times in these cases. That doesn't mean that you as an individual can sue over it, but that's their general role. If they fail, they may face indictment. The Broward County Sheriff, the SRO at the Parkland incident, he was fired for his failure to do what he was hired for. It's just like a waitress. If they hire a waitress to wait tables and she does not do it, she had a duty to do it in one sense, in kind of the vernacular sense. There was no legal duty for her to do it, but there will be repercussions. She would be fired, obviously, with cause. So Ida's statement is mischaracterizing what the Supreme Court has held. Because again, the Supreme Court was dealing with 14th Amendment due process and the 1983 lawsuit, which does not allow for a cause of action like she was hoping. I hope I've been clear. I hope this is informative. I hope you have enjoyed it and have a great day. P.S. Don't be an anarchist, because that's pretty stupid.